You are live, I hope, Madam Chair.
I hope we're live. We just went live. Welcome back, folks. This is Wednesday, April 12th. House Corrections and Institutions Committee, and we're picking back up. And I know that we've had a lot of conversations about MAT. I know that Annie Reniciano, I always have trouble, Annie, with the last name. Annie came in, I believe it was Friday, the end of January, maybe the beginning of February, to give us an overview of MAT. And I know it's brand new to folks. And now that you have a little bit more information under your belt, probably just enough to be dangerous, it would be good to bring Annie back and have a discussion about MAT program within corrections, and also maybe talk about the transition of someone as they're re-entering the community. I can open it up to Annie to give another brief review of MAT, or we can go right into questions. What would the committee like? I think a brief review, and then that will spark questions. Well, welcome back, Annie.
Thank you, Chair Emmons, and you said my name beautifully.
Oh, God. Thank you.
See, practice does make for perfection.
Yeah, it does. It
For
does.
40 years, you're pretty great.
Oh, shut up. Still working on it. Go ahead, Annie.
Yeah, all right. So Annie Ramnicianu, for the record, Department of Corrections, Director of Addiction and Mental Health. So again, it was this body that created history.
Uh-oh, you're freezing up. You're freezing up.
Shut the video off.
Maybe you need to shut your video off because you're kind of in and out.
Let me go right next to the. I'm sorry. I'm visiting my mom, and in New York City, and so I have concrete walls, and I've now moved next to the router.
Okay.
So hopefully that will help.
Yeah, you were fine earlier. So
I know it might just be utilization in the neighborhood.
Yeah.
But anyway, so this body, as I was saying, really made history, taking a very strong leadership role in the passage and really creation of Act 195, which was the first law in the nation to establish criteria for opioid use disorder and opioid use treatment, not only for individuals in the community, but also for those who are incarcerated. It was also really groundbreaking because this body and just
You're going to have to take off your
governor
video.
decided that care should be
Yeah.
that care should be inside of the facility should be commensurate with the community standard of care. So, as I said, this was the first and only law in the nation, and actually served as a model policy law for many think tanks who were examining the issue of this time. So it was really amazing. What's also amazing is that there's only been one modification to Act 195 since its passage, and the modification was simply to include language that the community social behavioral counseling piece be commensurate again, tied again to the Vermont Department of Health rules that govern opioid treatment in an outpatient setting. So the only amendment was, again, strengthening the connection that what the department was charged to do was absolutely commensurate with what was happening in the community, which is governed by the Vermont Department of Health and their APA rule. So the way to think about MAT treatment and the groundwork that Max really laid is really helpful, is that the treatment, all treatment really exists in workflows, starting with screening and assessment, and a longitudinal path by which different levels of provider make the determination of the individual as to whether or not they have an opioid use disorder, moderate to severe, and whether or not that level of disorder clinically is medically necessary to be offered medication-assisted treatment. Again, this is all voluntary. Assenting to any of these screenings, assessments, the treatment, what type of treatment is all voluntary. And it is a pathway. So breaking down those workflows. Somebody who comes in at intake, and you heard Max say that medication verification is part of the initial receiving screening. Verifying somebody's medication, contiguous upon intake, was again another piece of legislature that this body took the lead on. Once we find out that the person has an active prescription for buprenorphine in the community, which is in our Vermont prescription monitoring system, is a database that all of the providers have access to, then that prescription is simply continued. An order is placed by the provider in the system, and the individual would receive the medication. So that's one track. Somebody who has a verified prescription of buprenorphine and or methadone. With methadone, as I mentioned in the earlier testimony, we do not provide the methadone. As soon as we learned upon intake that the individual was in methadone, we would be starting the DEA and Vermont Department of Health established protocol for procuring the methadone from the hub the medication from. If the hub that was prescribing the methadone is proximal to the facility that they're lodged at, then they remain the prescriber of authority. If that hub is not proximal to the facility, then we begin the protocol for guest dosing. We would be applying from the home hub to the hub that would become the prescriber, and including Tony Folland, who is our state opioid treatment authority, the SOTA, at the Vermont Department of Health. The paperwork gets filled out, goes to Tony, goes from the home hub to the guest dosing hub. Everybody talks. It's a standard protocol. And the guest dosing hub would agree as to the direction of the home hub to continue the dosing. The home hub always remains the prescriptive authority and essentially the doctor to the individual. But the guest dosing hub agrees to carry it out because they're closer to the facility. This is important because the medications need to be picked up on a regular basis, and in the beginning, possibly even on a daily basis. So correctional officers go to the guest dosing hub, pick up the medication in a very secure, controlled fashion. It's called a chain of custody protocol. This again is approved by the DEA of the Northeast region. And the locked box is brought back to the facility. There are complicated, oversight of checking every single vial, the individual's name, the dose. There's double checking and redundancies on both ends, on the receiving end and on the giving end. And then that's all logged into the facility. And that's how the dosing occurs. Okay, I'll stop there.
Maybe you were going there, but I know when we were doing this years ago, DOC could not store any methadone on site. And so you physically have to go pick it up. But now can you store a supply on site, or do you have to do a daily trip?
In some instances, we can store on site. And it really depends on the storage capacity of the facility and whether or not it makes sense to do so. So it's a yes and also.
So let's look at some of the facilities here. So in St. Albans, is there a hub nearby in St. Albans?
There is a hub nearby. We work with the BART Hub Center system. And so I'll actually do it the other way around if you don't mind. The facility that is not close to a hub is Springfield.
Yeah. Brattleboro or Lebanon, right?
Yes. So that is the system, the correctional system that has the longest commute, the longest distance to a hub. All of the other facilities have a hub that is very proximal to the facility.
So we have a question here, Annie. Wayne?
So given that correction officers are going to do this, get any estimate of what the manpower requirements are just to go and get the methadone and deliver it back to the facilities?
Yes, we did do that calculation as part of our participation with the Attorney General and the opioid abatement, the settlement, the lawsuit. So I don't have the numbers off the top of my head, but I believe that we could retrieve that.
So say for the Newport facility, how far away is the hub?
Again, we are dealing with the BART healthcare system, and it is very close.
And the same with St. J.
And the same with St. J. And obviously the same with Chittenden too. Obviously, we're on Farrell Street there in South Burlington, and the Chittenden hub is next to the South Burlington High School.
We have another question, Annie. Tristan?
Thank you, Annie. We've all heard that diversion is a thing. Can you talk about where diversion happens?
Absolutely. Diversion happens across all of the facilities, and we have a very intensive data collection and monitoring system about diversion. It is included in a MAC meeting. Those are monthly, right? Or bi-monthly? Quarterly?
MAC meetings are at least quarterly.
At least quarterly.
Services.
Thank you. So part of that data and the report is reviewed at the MAC meeting, which, as you just heard, happens at least quarterly. Aside from that, this is data that I look at on almost daily basis, and I also have almost daily conversations with the providers and my counterpart who works for the contractor. So that's believe the answer to your first question. I think within the answer to your first question is, why do people divert? That is also something that we gather a tremendous amount of information about. We gather information about where the diversion occurs. Is it occurring in the Medline? Is it occurring in their cell? Are people being caught actually giving medication to another person? We look at those different buckets. We also look at their dose and what is happening as part of the story of diversion. In clinical terms, this is called a functional analysis. When someone is charged with diversion, they are given a disciplinary report, a ticket. The officer logs that information in our offender management system, and we have a reporting mechanism by which the healthcare providers who are charged with managing this go into the system on a daily basis and retrieve all of those reports for the day, for the time period before they last looked at it. And then they break it down in a format much like what I've just articulated. Where was the diversion? What was the nature of the diversion? They categorize it. They also go and meet with the individual to do the functional analysis, which basically walks the person through what was the function of the behavior, what were their thoughts, feelings, and choices. Were there any other choices? What was driving all of this? They engage the person in a non-confrontational, non-judgmental conversation about the circumstances surrounding the diversion. I'll go to an example recently. We had our MAC meeting at Northern State yesterday. They gave a beautiful presentation about all of this data. And when I asked the follow-up question, which was, of the people who were found to be diverting, not in the Medline, but in their cells, was this related to any recent tapers due to disciplinary reports? And they said yes. I also asked whether or not it was related to grievances that they had received because the individual was reporting craving and did not feel that they had been titrated to the appropriate dose. And the answer was yes. So diversion, people divert for a lot of different reasons. It's not only, which is what I think most people go to in their heads, not only for sales or for benefiting themselves financially. Because we provide buprenorphine, any smidgen of buprenorphine is literally on the market of the prison system. It's worth like $1. It's worth like $5. They're not doing it for, for financial gain. We are learning from this analysis that a lot of people are diverting because the providers have not been able to, or the assessment information has been complicated. We believe that one driver is that they are not being dosed at the dose that they need to be at, which is higher than what they're receiving. And so they are saving a little bit for later because they want to stave off the cravings that they're having. And another reason for diversion is likewise, if you've been caught with diverting or you've been charged with diverting, which might also have been that you were not receiving the dose that you really need. What do? You withhold, and then your dose may be reduced. You are actually sort of forced into holding back again, which might lead you to be charged again with another diversion. So it's kind of like a downward spiral. And then there are truly people who are diverting and they're using pen caps and they're doing it right in the Medline. Another measure that we look at is called COWS. COWS is a clinical tool that when you reduce somebody off of their buprenorphine, or it would actually be seen, it's the withdrawal protocol that we use even for people coming in who we know have heroin on board or whatever. It is a list of subjective and objective criteria. And when we reduce somebody on COWS, we also monitor with that symptom checklist. So we're also able to see if we do taper somebody and they have a 0 score on COWS, that really probably indicates that they were not taking the medication, they were diverting for whatever reason, and the taper is probably indicated, and the provider is going to take that into consideration in their treatment plan. But you had a follow-up question.
Thank you. This was, can you just say, sounds like you really know diversion is not a mystery. You track it with so much data. I would have assumed maybe it was more stealthy. Can you just give me some insight on that?
You faded out a little bit. You thought it was more stealthy?
Yeah, I would have assumed diversion is not something you have as much data on. It's stealthier. Can you just help me maybe correct that misperception?
That you don't see it.
That you don't see it.
Yeah.
So, I would really, say that this is a joint effort, providing safety and security and certainly safe medical care is a joint effort between security officers as well as medical staff. The dosing procedure is critical to this safety and is obviously one key point where we gather a lot of data. Individuals are called in for a separate Medline and are required to sit on their hands. They have typically a smock on as well. And they are observed not only by medical staff when they're provided the medications, a mouth check is done, they're provided the medication, the person dispensing the medication observes that the medication is going under their tongue, which is what the protocol is. This is a medication that cannot be swallowed. It needs to melt. It's absorbed sublingually in the sensitive tissue under the tongue. If you swallow it, the contents of your stomach, the gastric acids, make it inert. So it must be absorbed sublingually. So that is the first point that we look at signs for diversion. Literally in that mouth check, nurses may see a pen cap or something else being used to capture the medication. The person swishes it around with their tongue and pushes it into the vehicle that they intend to save for later. So that's one area that we gather information. Another area really is almost all security. because if somebody is walking away from the med line, the officers are also making sure that each group is leaving in an orderly fashion. They're keeping their hands to themselves, and they're looking for signs and symptoms and behaviors of the transmission of or nefarious use of the medication. So that's the second point. Then the third point that really is all security as well is the cell shakedown. It's intelligence gathered throughout the facility at certain points in time, whether that's through communication, observed behavior from unit officers, shift supervisors, etc., that they might go in to shake down a cell or shake down an entire unit. So it's through all these means that we gather information about diversion.
Any other questions on diversion? You probably got more information than you ever wanted.
I'm sorry.
No,
Better to be
fine.
thorough to so that, you know, the less questions I end up having, it means I've hit the mark.
Really appreciate it, Annie.
So one other question that keeps coming up in the committee is, how long do people need to be on buprenorphine or methadone? Can't they just be stabilized and then move off it? Could you talk a little bit about that? And if you do get into tapering off, what triggers that? Why do you do it? And why do you not do it in some situations?
Certainly. So as we've spoken to previously in this testimony, you know, the medical decisions are made by the providers. They have medical autonomy. Our role is to question and ask for the rationale behind that medical decision making. It's never to make the decision itself. And as I've also said previously, specifically regarding methadone, that is the sole responsibility, sole decision of the home hub, who maintains contact with their patient in concert and collaboration with our medical providers. But they will direct medical providers to gather vitals, to gather urine screens. They will direct the providers to set up possibly a face-to-face meeting if there's the need to directly correct vitals, to directly collect information that they feel is important in the treatment plan of the individual. And then we would simply be transporting the individual to them for those purposes. So I just want to say that first and foremost, that it's not the Department of Corrections deciding whether or not somebody tapers off of this. That is a decision between the provider and the patient. The provider might be our provider, our contracted provider, or it might be the provider at the hub instead. Now, your second question, Chair Emmons, was really the length of time for treatment. You know, is this a chronic disease? Can it be treated adequately? What is best practice? What medical wisdom in the treatment of this?
You're fading in and out again, Annie.
Uh-oh. I'm sitting still and I have my mic right next to my voice.
Now it sounds okay. So we didn't pick up as to when they're tapered. I mean, we heard that it's a medical provider's decision. And then you start talking, do we see it as a chronic disease, and why can't folks taper off?
Okay. So what we know from national and global research is that for people with moderate to severe opioid use disorder, who would be on MAT, some form of MAT, it takes approximately, this study was done with methadone patients who were treated in the community, not in a correctional setting, an average of 7 years before they stabilize. The social determinants of health are so impacted by the disruption of managing an opioid use disorder that it takes 7 years for somebody's life to really get back on track. And that's in the community. So these are people who have much more wellness, much more social capital, and who have not been incarcerated and have had not most likely had the level of chaos that the individuals that we have and within our walls, what they are currently experiencing. I would, again, this is just Annie wisdom, but I would say that for the people who are incarcerated, you could probably add at least a couple of years on that 7 years. I don't have any science to back that up, but these are individuals who are dealing with complex issues, complex cultural, complex social, complex medical, as you heard previously, complex everything, and do not have stability in their lives. This is a key medical treatment to help them start addressing all of those issues. And it's always going to be a decision between them and the provider. The Department of Corrections does not have any say in that matter. We don't direct medical care, and it's not tied to their legal status. So it's
So
an
Annie-
individual choice or a provider choice.
So that's very helpful. I also think you're holding your mic a little too close. Now,
Sorry.
this is not feedback, but it's a little too close. And I think it's really hard for the layperson who maybe has not experienced any issues of any addiction issues of any within their family or friends or anything, to have a hard comprehension of understanding it would take 7 years in order to work through an opioid disorder, and possibly longer if you're incarcerated. I think that's hard for people on the outside to grasp. So I really appreciate what you stated. I think it helps us in processing the information. So that being said, I know the committee may have some questions. Wayne?
Yeah, I'm just kind of shocked. I mean, my father smoked, a lot of smokers back in the old days, and he quit smoking, and it was a long and difficult thing for him to do. But we had a campaign years ago, anti-smoking campaign. It was anywhere you looked on TV, it was don't smoke, and all the things about smoking. I don't see that with opioid addiction and the other addictions. What's going on? How come we don't have a campaign, the same kind of educational campaign that we had for cancer and cigarette addiction?
Well, I think that's too fast. You can have a campaign about trying to prevent folks from using, whatever it may be. But the real issue is once you start using, opioid use is very, very different than alcohol. It's very different than smoking. It does some fundamental changes to your brain structure. And that's the issue once you have an opioid addiction, is there's been neurological changes in your brain, and you don't get that necessarily with alcohol. You get health-related issues such as heart or liver or vascular, and the same with cigarette smoking. Opioids are totally different. I don't know if you can weigh in on that, Annie, or not.
I'm happy to, and I think it's a question for the Department of Health, because that would be the state agency to be launching that strategy based on the science. And I think it's a worthwhile question for a larger conversation. We're obviously in the Department of Corrections dealing with the result of somebody's addiction as it relates to us providing health care. Our health team and our healthcare provider, we don't punish people by withholding medical care that's deemed medically necessary. By the 8th Amendment, we must treat disease. And Vermont has really been a leader in identifying that this really means all disease. We did this with hepatitis C. We've done this across the board. Other states are not so prescient, and they get sued a lot because they're not providing the standard of care that Vermont does. So I kind of think of us as the caboose on the train. You're right. There needs to be a very aggressive campaign about the harms of all addiction, including opioid use addiction. And unfortunately, we are left with people who sadly have fallen to this. And we simply have to treat them.
So we have another question, Annie. John?
Do you have any feel for the effect of possible contraband that finds its way into the facilities is having on the treatment that you're trying to provide?
That's a great question. We provide the mono, meaning single medication, which is called Subutex. So we literally only provide buprenorphine, and the generic name is Subutex, pharmaceutical name. In the community, Medicaid has on their formulary Suboxone, which is a combined dual product, buprenorphine and naloxone. The decision that Medicaid, that DVHA made to choose that drug for their formulary was due to some of the evidence that naloxone, when it's paired with buprenorphine, prevents overdose, because in the community, sometimes people misuse a medication, they grind it up, they combine it with water, and they shoot it with a needle. If naloxone then acts as an agent to prevent death by overdose if it's misused in that way. I tell you all of this because the pill is different and is a different color and a different shape. So this is one way we know whether something is introduced and it's contraband, because in the community, you can only get Suboxone. So if Suboxone turns up in the facility, somebody brought it in. And that's how we're able to determine. I don't hear a lot of reports about Suboxone as contraband, but then I have to say we have a lot on our plate and I don't look at those reports regularly. And I don't have lived experience or direct knowledge of what our contraband seizures look like. Security would probably be able to tell you more.
How do you test for naloxone?
Say that again?
How do you test for naloxone?
Well, the pill is a different color and it's a different shape. So when we bring it to medical, we can bring it to medical and we can send a picture of it to our pharmacy subcontractor, and or, you know, it's possible that some of our medical staff would be able to recognize it. And so we're able to do a visual verification.
So if someone's consumed it, you don't have a way of knowing?
No, we don't.
Okay.
We don't. They would just test positive for buprenorphine, and we wouldn't have any way of knowing whether it was whether it was external contraband or not.
So one of the reasons that we really looked at starting the MAT program while someone was incarcerated, DOC did have policies in terms of how to taper folks off if they came in and they were on a medically assisted treatment program or some type. They did do a tapering off. And there was concern that, and this has been substantiated, that if a person has an opioid disorder, use disorder, and it's not managed, I'm not going to say the word under treatment, but I'll say it's not being managed. When the person is released from an incarcerated setting, those first couple of 3 days is really crucial because the person will really be going out to get a high. And they may get a dose that results in an overdose and a death. So we were really looking at providing medical services of this nature while a person's incarcerated to really help them when they re-enter the community to be successful. That was really one of the goals for that. So I also just want to put that out on the table.
You know, that's
Annie?
absolutely correct. And then the follow-up I would provide the committee is that this past summer, the Department of Justice actually promulgated a decision in accordance with the Americans with Disability Act. And the position that they promulgated was that not providing medication-assisted treatment, all forms of medication-assisted treatment within a carceral setting was a direct violation of the Americans with Disability Act. So over the summer, I had many meetings with the DEA and SAMHSA, which is the Substance Abuse Mental Health Services Administration, and the Bureau of Justice, which is our federal prison system, was scrambling, working in concert with the DEA and with SAMHSA, because they, as a federal carceral system, was out of compliance with the Department of Justice. And they scrambled all summer to start to build what we have built here in Vermont to ensure that the whole Bureau of Prisons, every facility, actually offers medication-assisted treatment.
So as the committee can see, we've put in a lot of initiatives over the past years that are really looking at providing the most humane treatment of our folks who are under state custody. We've done a lot of initiatives. We've ensured that folks who are on any medication when they're coming into a correctional facility, that medication is continued, because there were issues where it was not. And we put in legislation setting up that program. We set up this program. We worked really hard with the Department of Health and DOC in setting up this MAT program. We also worked in terms of folks coming in with mental health issues. We spent a lot of time in this committee working with Department of Mental Health as well as Department of Corrections to provide a coordinated service approach to folks who are incarcerated with mental health issues. So we've put in an awful lot of initiatives over the last 10 years, 12 years. So when sometimes we may hear that our system is not taking care of people, is not being thoughtful enough and trying to set up folks who are incarcerated to be successful when they re-enter the community, I think we need to be pretty cognizant of those initiatives and statutes that were put in place. So we've done a lot as the state of Vermont, and we are looked to at being in the forefront of some of this, and that we should be proud of that.
Yeah, I mean, personally and professionally, I agree with your statements. When Max was presenting, I was just thinking I wanted to add that, you know, every single stage of our workflow includes not only the NCCHC standard of care, but we look to Medicaid clinical guidelines, and then in every single point of contact included is whatever statutory obligation this law has asked us to provide. Again, is much, much higher standard of care than what most states provide. When you do hear negative information, we are always open to receiving that information. But I would say that it's typically not a policy change that's going to improve whatever you're hearing. It's continuous quality improvement.
It's not a policy change.
It's a continuous quality improvement issue of the work of our group inside of the department to ensure that the contractor is adhering to the contract and our policies and procedures, which again, all reflect the intention of this body.
So we need to finish up because our other folks on the other issue have come in. It's a forensic issue, Annie. The
Yes.
ones with the little F, not the big F.
Yes.
There is a difference. Katie might get into that a little. There is a little difference. Any other questions here for Annie on this? I hope this has been helpful for folks. And Annie's a great resource if you have questions or want to do a little deeper dive in the MAT or healthcare. I think Annie's a great resource, as is Max. So I would like to thank both of you for coming in today. Sorry if we interrupted at all your vacation time or your time with your mom, but thank you so much, Annie, for zooming in with us.
Bye.
So, okay, take care.
Thank you.
Thank
Thank you.
So let's do a shift here to, it's on our webpage. It's a bill. Again, we don't have physical ownership of the bill. It is in House Judiciary. And it is dealing with setting up a program for a forensic program. And there is also language there about beds. And it is, Katie, why don't you come on up to the front, S89. And what we have posted is as it passed the Senate. And we're gonna have a very limited view of this bill because it really goes into the forensic treatment program. But we need to have a little understanding of what we mean by forensic.
Okay.
And what the intent of the bill is, and then where the folks would be housed. Because we need to look at, and we did reach out to BGS too, right?
Yes, the commissioner is supposed to be here.
Okay, well, I'd like to get started because I know, Katie, you're probably on a really tight schedule. You're
Well, I
going-
can stay with you for a half hour.
Yeah.
And then I'll.
Yeah, you're going
Is
on a
that-
tight schedule.
Okay.
So,
Good morning.
good morning. If you could introduce yourself.
Sure. Katie
This is your
McLean.
first time before our committee. this year.
It is. I know, that's hard to believe. Katie
Yeah.
McLean, Office of Legislative Counsel. So for the members who I haven't worked with before, I typically staff issues related to human services, public health, mental health. So that's what brings me in.
Mhm. Welcome.
Thank you.
And we also have Karen Barber, who is with the Department of Mental Health, and she's their general counsel, and we can always refer to you, Karen, to maybe after Katie, or depending where the questions go. So welcome. So Katie, it's all yours.
Thank you. Do you like the document shared on your screen, or does everybody have it
I
on?
think we've all got
You've
it
got
up.
it. Okay. So S89, maybe I'll just take a step back and sort of tell you a little bit about the bill and how it accomplishes what it's trying to accomplish. So the idea behind this bill is that there's a population of people who are involved in the criminal justice system. They've either been deemed incompetent to stand trial, or they were adjudicated insane at the time of the offense. And then what this bill does is it creates an avenue by which some of these individuals, if they're deemed clinically appropriate, and if they're deemed to be a serious risk of danger to themselves or to the community, that they would be placed in a new program. And this would be a forensic facility program. The program would not be a hospital level mental health treatment facility. It would be a different type of programming than hospital level care. It would be in a secure setting. And it would be for the programming and treatment of individuals with both mental health concerns and developmental disabilities. So it would have sort of shared jurisdiction over the facility by the commissioners of Dale and DMH.
So let me stop you there.
Yes.
So they have not been adjudicated, and they do not have a sentence.
possibly adjudicated if they were found insane at the time of the crime. At the time of the
And
crime.
that's pretty high standard that usually can't be met. That's a high defense. That's a defense.
Mhm,
Insane at the time of the crime.
mhm.
Competency to stand trial is different.
Yes, that means the person hasn't been adjudicated yet. That's, well, I guess a competency assessment could be done at any time really during the proceedings, but often before the judicial proceedings have progressed to a trial stage, there would be a request for a competency evaluation, and it would be determined whether the person is competent to stand trial. If they're not competent to stand trial, they might become competent to stand trial in the future, in which case they could be tried at that time.
So if they're deemed not competent to stand trial,
Mhm.
would they be housed in this new forensic facility?
Not necessarily, but they could be.
It's complicated.
Yeah.
So forensic, so this facility won't be where folks go to make a forensic determination of whether or not they're competent or.
No, so whether or not they're competent will be determined before a recommendation is made to send a person to this program.
I'm just trying to wrap my mind around the term forensic, because
Mhm,
typically forensic is the diagnostic
mhm.
things that go on. If they're not diagnosing here, then I don't see the whole picture.
Yeah, so the assessment takes place, the competency assessment, this bill doesn't change that. That takes, the option to have a competency evaluation can be raised, as I said, at many places along the process of criminal adjudication. What this bill does is it sets up a process by which a person who is meeting this criteria, the commissioner, the appropriate commissioner, whether the person has a mental illness or a developmental disability, would take a look at that person's case and circumstances, such as whether the person poses a high risk of dangerousness, whether the person can receive clinically appropriate treatment in this setting, whether this is the least restrictive setting necessary to serve this person's need. That's a standard that's established by the US Supreme Court, that it has to be the least restrictive setting to serve the person's needs. And if the commissioner feels that this person is an appropriate candidate for the forensic facility, they would have to make an application to the court requesting that treatment is received at a forensic facility. There are already many sections in Title 18, the health title, that give a process for how somebody would end up within the custody of the Commissioner of Mental Health or Department of Disabilities, Aging and Independent Living. So this bill in some sense isn't recreating the wheel. Instead, it's sort of creating a process within the existing framework by which a person could be committed to the forensic facility.
Chip and then Michelle.
So a person could be ordered by the court to be in this facility if it's been determined at, for instance, arraignment, that they are a danger to themselves or others, or they appear to be incompetent without understanding of what's going on around them.
Mhm.
Is that accurate to say?
Yes, they can only be, yes, and they, under this structure, they could only be ordered to a forensic facility by a court, but it wouldn't necessarily, for example, happen at arraignment. There's a whole
Right.
process set out.
Right.
So maybe if it's at that point where there's a competency evaluation that's done, at that point, the commissioner may become aware of the individual and see if these other criteria are met. And if so, whether the commissioner wants to file the application to have the person treated at the forensic facility.
Okay, that carries it on. So, yeah. Okay.
Michelle and then Mike.
Yeah, I'd like to hear a little bit more about sort of I guess you would call it the admission criteria for
Mhm.
coming into the facility. So I know there are cases that have been in the news within the last couple of years where somebody committed a crime, mental health appears to be a component, and there isn't a good place to send them.
Mhm.
So somebody who's found guilty, for example, would they be eligible to go there or not be eligible to go there? Because like, from what I understand, the Defender General just this week said there was an individual who went from one of our incarcerated facilities to a mental health facility in Vermont. Like, would they instead be going to the forensic facility in the future, or would they not be eligible for that if they already were actually sentenced?
So I'm not familiar with that case. I'm not gonna comment on it. What I will say is that within the bill, there is a rule. So this is the bill as came over from the Senate. Your colleagues in the other House committees have not begun their work yet on this bill. So, you know, anything is subject to change. But what came over from the Senate is a rulemaking section that requires Dale and DMH to start and hopefully finish a rulemaking process, which covers the admission criteria for a person coming into the facility. It provides what I think of as sort of guardrails, different elements that have to be part of the admission criteria. And it also talks a little bit about process. What will the process be like before it's determined that somebody should be in the forensic facility? And I'm happy to walk you through that language.
Okay, I'm also wondering in terms of the timing, like there are some folks who would likely land there who have committed some pretty violent crimes.
Mhm.
And if you were in the correctional system, you would have a sentence and you would know how long you were going to be held.
Mhm.
How would they determine that in this particular facility? How long would somebody, I mean, would you have a sentence of how long you stay there, or it's until you're well enough to go through competency and then you go back into the criminal justice system, or how will that work?
So as I was saying, there's an existing structure for mental health orders in this case. And this is sort of weaving this new facility into the existing structure. So under the existing structure, there is an initial order that's made. The initial order, I believe it's 90 days. Karen will correct me if I'm wrong. And then after the 90-day initial order expires, there can be a follow-up application for continued treatment, and that can be for up to a year. That doesn't mean a person can only be held for an additional year. I would assume that the commissioner, if they felt that the person needed to be committed to a forensic facility after the year, could submit another application for continued treatment, and there would be a review, you know, every year moving forward to determine if the person still needed that particular level of care. I don't know. I could ask.
Well, I think people need to be clear. Is this a person that is already sentenced and will go to a forensic unit? Or is this prior to any sentencing?
Well, if the person is incompetent, they wouldn't have been sentenced.
They would not have been sentenced.
If they are not competent, because they haven't been tried yet. If the person is determined insane at the time of the crime, I'm not sure if they would have been sentenced prior to being referred to the commissioner of Dale or the commissioner of mental health. So I'd have to ask Karen and.
Because my simple understanding is this would be looking at those folks who are not sentenced. If there is a sentence, then it's really over to DOC, and it would be housed in a correctional facility, not in this particular forensic facility. That's my understanding on a real simple.
Yeah, and that might be right, but I would ask DMH and Dale to weigh in on that piece.
Karen is right behind you. Karen, Barbara, can you just identify yourself for the record and maybe clear this up, yes or no?
Sure, yes. Karen Barber, General Counsel for the Department of Mental Health. And that is correct. The only people eligible for this facility are those that are either currently incompetent to stand trial, which means they haven't gone to trial, or those that were found insane. And if they were found insane, that's a defense. And so they also wouldn't have been sentenced.
So that's why we turned the little f and the big F for folks that maybe have dealt with this in the past, because we've talked about a forensic unit in the past that would house both. the folks that this bill is addressing, as well as those folks who have been sentenced. And this is not for those folks who have been sentenced. That's why it's under DMH and Dale. Okay, so I got Wayne and then I got Connor.
So the way I read this under application, I'm trying to get my head wrapped around what are we trying to deal with here? What are we trying to solve? Because if I read, application for an involuntary treatment, it reads, an interested party may, by filing a written application, commence proceedings for the involuntary treatment of an individual by judicial process. That suggests to me that if I had a family member that I believe was mentally unstable, that I could go to a judge, a court, and get a determination that might allow that person or me to have that person put into this facility. Is that correct?
I
I'm
think
not
it's
saying-
a criminal
You're
activity.
reading,
It doesn't say anything about
This is,
criminal.
this is existing law. That's not the amendment.
Okay.
Yeah.
The forensic would be dealing with folks who are in the criminal system, correct?
It would, be people who are criminally involved, and the process for that would be the commissioner filing an application, and they have to specify in the application, I would like to see this person treated at the forensic facility. This is why this treatment is least restrictive, clinically appropriate, and the person would be eligible for this facility.
It's not a person in a severe mental health situation, severe acuity, to go to a forensic unit. They would go to the state hospital or down to
Yeah.
the retreat. So
Yeah,
I
and
just want that to be really clear for folks. This is for folks who are involved in the criminal system. There's been a charge of a criminal act, but they may be deemed incompetent to stand trial, or the defense may use the insanity plea. And the insanity plea is a very, very high standard that usually that doesn't hold up. These are folks that have been charged with a crime and are involved in the court system, but they have not been sentenced.
I understand that. So is this just to deal with the cases where their defense is going to be insanity and you got to have a place to put them?
No, we're dealing with folks who may be deemed incompetent to stand trial, so they
Right.
can't go to trial.
Either way.
If a person can also plead a defense when they do go to court, that they were insane at the time of the crime, and that's a very high bar to prove.
Right, so, and this is
Sentence.
pre-sentencing. So is this just for that duration of time, pre-sentencing, that they go there until they either become competent or whatever, it can go through the judicial system? Is this a temporary housing of people that are in the system?
Probably depends on how long the commissioner who is filing the applications decides that the person needs care at that particular level. So I imagine there could be situations where the person is on their initial order of 90 days, and within that time, they regain competency and can be tried. There would also be cases where maybe an application for continued treatment is filed. That's the year-long application. That particular term reaches its end. The commissioner looks at the case and feels that that person is still dangerous. This is still the least restrictive setting, and still meets the criteria to be there, and they would apply for another application. So it could be a longer stay or a shorter stay.
Could it be indefinite?
I mean, the order always
Well,
has a
it
set
stands-
time.
Well, it stands, but it's technically, someone that was really had an issue could essentially never recover to the point where he could go be competent to stand trial and could stay in there forever.
Unless the commissioner might at some point say, this is no longer the appropriate place for this person. There would be another appropriate place for the person. For example, Middlesex, the Secure Residential Recovery Facility, might be the most appropriate place now for this person to receive treatment. Or this person, while not competent to stand trial, maybe is no longer a risk to the community, and there's an appropriate community placement for the person.
So I'm cognizant of Katie's time. She's only here for 10 more minutes, and I know we can have Karen weigh in on some of these questions. So Karen, just be prepared because I want to use Katie as much as we can right now. And we got more questions, but I also want to get to the beds. Okay. Because that's what we need to really look at, is the beds. So we got Connor, Chip, and Kristen.
So I'm just trying to get my head around it. It's a DMH facility, but no.
Yes,
Okay.
and.
Yes, and.
Okay.
Yes, and it will be run by DMH and Dale jointly.
Okay, but it's not a hospital?
It's not a hospital,
Right.
but, well, we'll get to that piece.
Okay.
yes.
We're gonna
Uh,
get there.
Would and maybe it's not for you, Katie, but I'm trying to, like, the frontline staff, are we thinking psychiatric technicians or correctional officers or a hybrid or?
I think it would be more clinical staff, but I'll leave that question for Dale and DMH to answer.
Okay, thanks.
Chip and then Tristan.
So I think the incident that Representative Boswell was talking about was Mr. Garan, who was determined to be incompetent. And charges were actually dropped by the state's attorney in Burlington. They were reinstated by the Attorney General's office. Mr. Garan, after a prolonged stay in a facility such as the forensics facility we're speaking of, was determined to be competent, stood trial and was convicted, and now is showing symptoms of incompetency again, and has been placed out of the corrections and back into a secure facility, non-corrections. That's what happened, and that's very unique. It's pretty unique.
But he can't stand for sentencing until.
Right, and he has not been sentenced. Right, that was the end of the
Tristan.
Madam Chair, this bill, can you just understand, does our committee have a certain scope for this bill?
The beds.
The beds and sort of
The beds.
what about the beds?
The beds.
Should I get there? Okay.
Talk about the bed.
So the bill itself does not have a whole lot of language about the beds. We have a purpose section, and that is really all we reference in terms of beds for the bill. Everything else is process about how a person would be admitted to this type of facility and a few rulemaking provisions. But the idea at the moment, and again, DMH and Dale can speak to this, but the idea is that right now there are, at the Vermont Psychiatric Care Hospital in Berlin, there are 3 units, and that one unit would be, I don't want to say taken offline, but repurposed. A 9-bed unit would be repurposed for the purpose of being a forensic facility. Right now, that unit is licensed as a hospital for hospital beds, but the forensic facility would be a therapeutic community residence, which is a license type that is managed by Dale. So Dale would have to license that unit within the hospital as a therapeutic community residence. So it would no longer be hospital beds. It would be a different standard. And there isn't language that specifically directs that is to be the facility used. Instead, well, we have a purpose statement that says an initial forensic facility shall be located in the 9-bed unit of the current Vermont Psychiatric Care Hospital. So this doesn't close the door that at some point it may be at a different location, or that there may be more than one forensic facility. This is just sort of saying right now the thinking is that the initial facility is at that 9-bed unit.
So why don't you bring us down a little bit further into the definition piece and what the forensic unit being secure means.
Great point. Okay, so if you are following along, we're in section 1A and we have the definition of forensic facility. So it means a residential facility licensed as a therapeutic community residence. That's what I just mentioned, for an individual initially committed pursuant to, and then we have a list of 134822, 13 VSA 4823. These are individuals who are coming in through the criminal door and who are either due to mental illness or developmental disability, can't be tried, or insane at the time of the offense. And these are individuals in need of treatment or further treatment, within a secure setting for an extended period of time. And then we have language in subdivision B that says a forensic facility shall not be used for any purpose other than the purposes permitted by this part or chapter 206 of the title. As used in the subdivision, secure has the same meaning as in 7620. So the definition of secure in reference to 7620 was adopted when the Middlesex facility was created, the secure residential recovery facility was created. Then let me bring you to the definition of secure.
That's on page 9.
Thank you. Okay, so page 9, subsection E, we have as used in this chapter, secure when describing a residential facility, which is what the forensic facility is, residential beds, means that the residents can be physically prevented from leaving the facility by means of locking devices or other mechanical or physical mechanisms.
So what that is saying for folks who have been involved in this a little bit, there's two types of security. One is the building is secure. The building provides the security. The other one is staff secure, where it's the staff that provides the security. There may not be locked doors, may not be hardened walls, there may not be a fence around the perimeter. But the staff keep the security for the folks to stay in that facility. So what this bill is saying is that it will be a building secure facility. And the thinking is that temporarily we would use those 9 beds at the state hospital. So it would be taken offline as mental health beds and would be transferred to be used as a forensic facility for those folks who are deemed incompetent to stand trial or pleading insanity at the time of the crime. Okay. So there's a lot of layers to this. One question I have is what is needed, if anything, for renovations or construction? And is BGS in the loop of this? That's why I've asked for the commissioner to be here. Number 2, and this gets into DMH, gets into our Medicaid waiver of getting Medicaid reimbursement for a state hospital. According to CMS, if you are over 16 beds, you are termed an IMD, Institute of Mental Disease, and you don't qualify for Medicaid reimbursement. When we went to build this new state hospital, when we replaced the Waterbury, the initial plan from the administration was 16 beds to stay to make sure that we received Medicaid for those beds. The push came that we needed more mental health beds than those 16. We worked with CMS and got a waiver from CMS for an additional 9 beds. So Medicaid covers our current state hospital at 25 beds. Gradually, that waiver for those 9 beds, or for the whole facility, because it's really the whole facility, we're gradually going to lose that waiver, possibly. And that's been talked about for the last couple of years. So the thinking is that as we get to that point of losing our waiver, particularly for these 9 beds, that we convert these 9 beds to a forensic facility that would not qualify for Medicaid. These 9 beds will be all on general fund dollars. And one question we have, would it put the rest of the 16 beds in jeopardy of receiving Medicaid? Because these wings are physically attached. And there are times in the past that if we had another situation near our current facility for mental health would violate the Medicaid requirements and we lose our Medicaid. So the question is, by converting this attached wing to another use, We lose Medicaid for those 9 beds, but do we put in jeopardy the Medicaid for those 16 beds that are mental health beds? That's the other layer to this. So I'm just kind of laying the groundwork for us to think about here. John and then Wayne?
No.
Oh, okay, Wayne?
So the other question is, in taking out the 9 beds, does that create a capacity problem for the mental health uses there? And how do we deal with that if there's this problem?
How many of these folks that would possibly be held in a temporary forensic unit be currently housed at the state hospital? That would be the question to ask. And that would be a dimension. Katie has to answer that.
I'm sorry.
No, I know, you're running around with this bill and others. But
Please reach out if you have more questions.
Thank you.
Thank you, Kit.
thank you.
Another question would be, is 9 the right number? Or is it just arbitrarily picked?
I think they're trying to comment where there were current beds and not have to build something quickly. This was a floor amendment on the Senate side, I believe, because people kept asking, where are you going to place these folks? You're building a program, but where are you going to place them? You've got to put them somewhere.
And it would be a real solution if those people are already in there that could go into that facility, then without building something, we do the best we can.
So we have Karen Barber here from, she's general counsel for the Department of Mental Health. And maybe you could weigh in, add some clarity, or maybe add more confusion. So welcome, Karen.
Thank you for having me. Absolutely. So I wonder if it makes sense to kind of give some context about why we're here and why we're proposing this, and then maybe go into some of your specific questions.
Okay.
Does that work? Okay. So why are we here? So basically, we have identified, and I think there's probably agreement upon between folks that there's a gap in the system between those folks who have been found incompetent or insane and don't need hospital level of care. So if you need hospital level of care, there is a secure setting for you to go to, right? You can be admitted to one of our hospitals. But if you don't need hospital level of care, there is no secure setting really available to them, because if you're incompetent or insane, you can't be held in DOC custody. So there's really a gap where we're talking about a small population of folks that have committed very serious crimes. I think you'll see in the bill, the language really talks about those who are being held without bail. So those are some pretty serious crimes that we're talking about. They've been found incompetent or insane, and they don't need hospital level of care. If they do, we already have a facility for them, right? We have 7 designated hospitals throughout the state, so there already are inpatient beds available. So we're essentially creating an entirely new level of care. This would be licensed as a therapeutic community resident, so very similar to the Middlesex therapeutic community residents or the new River Valley, which I came in, in the beginning of the session and talked about. So it would be licensed the same. We would have to make some amendments to the licensing rule, which you'll see in the bill, to kind of allow for some changes for the facility. But that's the idea, is that it's a residential level of care to kind of fill that gap. And it is a small number of folks. We don't know exactly how many right now because it's new and we've never had it before. So right now we have those units available, so it makes sense, but that's kind of where we got to. We were also trying to assure due process and make sure that anyone contemplated for admission to this facility would have all the due process that other folks in our custody have, which is why what we did is kind of added this into our current statutory framework for both DMH and Dale. In the DMH realm, to go to the secure residential River Valley or MTCR, which is what exists now, it's a special kind of order of non-hospitalization. We created this facility to also be a special kind of order of non-hospitalization. So you have the person would have an attorney through the Mental Health Law Project. A court would have to sign off on it. There's all sorts of due process involved in assuring that whoever we seek to place in this facility is really being served in the least restrictive setting possible. Because I think, as Katie mentioned, federal law is really clear that people must be served in the least restrictive setting possible under the Americans with Disabilities Act. And Vermont itself, too, is really clear. There's a very high threshold for involuntarily committing someone to custody. So that's what most of the bulk of the bill, right, you'll see is we're trying to create a pathway for people to get into the facility, because right now it doesn't exist and statute wouldn't allow us to place someone there. So most of the bill is trying to create that framework around it. Is that kind of helpful for giving some background?
Yes,
It is
we
very
do have a
helpful.
question, Karen. Michelle?
Yeah, hi Karen. So I'm wondering, I had somebody write to me who said that there was a person who was in Middlesex currently who I believe would meet criteria to go to this forensic facility if we had one. I guess I would like to hear a little bit about how is this forensic facility going to be different than the secure therapeutic facility we already have that we have running in Middlesex right now? And why couldn't we just use that as partly a forensic facility as well as for other types of people needing that situation?
Sure. So there's a couple different things that make, I'm just going to call it River Valley because we're about a month out from opening, and if that's easier, if that's okay for folks. So I'm going to talk about River Valley. Okay. One of the big differences is River Valley, we use Medicaid funding for, right? It's below 16 beds and we use Medicaid funding for it. Medicaid is really clear that you can't use funding for forensic folks. And it defines forensic as people involved in, there's kind of a complicated definition that we've negotiated through our 1115 waiver, which is what we do to deal with the IMD exclusion. And just to back up, the IMD exclusion is part of Medicaid, which basically says you can't use Medicaid funding for inpatient psychiatric facilities for folks between 21 and 64 if it's over 16 beds. And there are some caveats to that, but that's kind of the general exclusion. States can negotiate with the federal government what's known as an 1115 waiver, which sometimes gives flexibility. Vermont has always had for a long time 1115 waivers. We're in the middle of kind of that right now. And that's part of what Chair Emmons talked about, the wind down, right? So we have more than 25 beds at the facility. So we're having to wind them down. So that's kind of some background. So Middlesex was purposely built to be under 16 beds, right? So it's meant to be not part of that exclusion, so we can use Medicaid funding. It's also not meant to be a tool of the criminal justice system, right? Everyone in there is in our custody, and they're there to receive mental health treatment. This is a little different, right? We're talking about folks that need treatment, but part of the criteria of getting in there is that criminal justice involvement, and that means we can't use Medicaid funding for it. So that's one of the big differences between the two. The other is kind of the level of care. So they would both be licensed as a therapeutic community residence, but because of the potential public safety and acuity concerns of the folks that we're talking about serving in the forensic facility, the bill allows us to use what are known as emergency and voluntary procedures. That's the ability to seclude or restrain someone. It also allows us to petition the court for involuntary medication. If someone meets, again, that previously existing statutory criteria. Those are things that don't happen in Middlesex now. We did actually originally ask for those, and we released the EIPs and we didn't get that. But so it really is a different level of care than Middlesex, both in terms of funding and in terms of the care we can provide. Does that help?
It does help. And I guess I'm just wondering, is 9 the number because that's the number of beds that we have in the current facility? Or is that really the number that we're thinking, oh, we probably have, that's the number that we're going to need to be able to serve with people with this kind of issue?
You know, I think that's a good question, and one we don't have a good answer to, because again, this is an entirely new level of care. So we kind of have to feel it out. We think right now that's a number that makes sense. Will that be the number after we've done this for a couple of years that makes sense? I'm not really sure. I think it's really hard to tell. It also depends. This kind of goes to one of the earlier questions. This is not meant to be a place where people live forever. Again, our mandate is to serve people in the least restrictive setting possible. So the goal is for people to transition, right, to lower levels of care. because of the uniqueness of this population, we don't know what the length of stay will be. And so it also depends on the flow through the system that I think would impact whether or not that's enough beds. Does that
Thanks.
kind of answer your
Yeah.
question?
Yeah.
Other questions?
Yeah, thanks so much. I think like similar to Michelle, I'm just trying to, again, get my head around, like, taking inpatient mental health beds that are state run out of the system. I'm trying to say, like, is it just being driven by the 16-bed IMD? Or do we feel like we're in a good place now with the opening of the new place up in Chittenden County, that we have enough inpatient mental health beds? Because my impression has always been we're still in a bit of a crisis mode with emergency rooms filled up. And since we sort of decentralized the state hospital, we've been struggling just to, catch our breath. So again, I have anxiety about taking beds out of the system, even with the creation of new beds coming up there.
Absolutely.
Do we have enough, you think?
Yeah. So I think there's a couple answers to that question. One, I would say that when you hear about people waiting in emergency departments, by far the majority of those folks are voluntarily waiting for hospital beds. They're not folks that are involuntarily in the custody of the commissioner. VPCH by statute is only for involuntary people. It also is what we call a level 1 facility. So we have 3 level 1 units, I guess, across the state. So VPCH as a whole is level 1. There are now, I think, 26 level 1 beds at the Brattleboro Retreat, and there are 6 at Rutland. So those are our highest acuity beds. So those are the folks across the system who need the highest level of care. So they're staffed. Their staffing ratio is more, they're more intensive. So most of those people waiting in EDs are not eligible to go to VPCH. Those aren't beds that are available to them anyway, because they're not involuntary and they don't meet that level of care. Certainly we do have from time to time people waiting for level 1 beds, but it's by far not the vast majority of people within the system. In terms of the people who are using the beds, we think a couple things. One, we do have folks currently throughout the system who we think could probably be better served in this forensic facility. So we do anticipate some movement to the facility. The other thing is there are certainly folks in the current system who don't have great discharge plans, right? Maybe they can't at this point be safely served in the community, but they don't really need a hospital level of care. That is part of the reason why we asked to expand River Valley to 16 beds. The current Middlesex facility is 7. So we're more than doubling our bed number there. So we also expect that to open up flow within the system and be able to move people out of the hospital system that right now are waiting because there's not a good discharge option for them. So we do expect this to open up flow amongst the system. Again, it's kind of hard to know exactly what that's going to look like until the flow starts to flow, but that's kind of what we're thinking about in terms of why we think it's okay to take the 9 beds offline.
Thank you, Karen.
Other questions? Tristan?
What's the sort of typical average stay in this setting?
Excellent question. We don't know because, again, we haven't done this before. At Middlesex, I think it's 10 to 18 months, but it's hard to know what this may look like. One of the things I would note, because I think Katie talked about this a little bit, is competency, right? That's fluid. Someone could become competent, go back to corrections and stand trial. Vermont doesn't have a competency restoration program. So when they are with us, we are not seeking to restore them to competency. That's not our role, right? We are treating them for their mental illness. And our goal is to treat that, stabilize them, and then move them down to the next level of care. There is a section in, I can't remember if it's 89 or 91, apologize, the 2 bills are pretty closely related, that's asking us to study whether or not Vermont should have a competency restoration program. Should in the future there be a competency restoration program and part of the facility be used for that, if that's what the legislature wants, that may impact the time frame that people are within the system. So it's really hard to tell. Because again, we don't know exactly what it's going to look like, but right now, really our goal is to treat their symptoms either of mental illness or on the Dale side, and then stabilize them so that they can continue to move through the system. That's kind of a non-answer, I know, but I don't have a great answer for you.
I appreciate it.
Troy?
Has there been any discussion about time spent in a facility such as this counting towards any pending sentence?
I don't know. So, DMH is not a party to those cases. So I don't know what the judiciary or defense bar or state's attorney may be thinking about that.
Okay.
So Karen, could you weigh in on if this 9-bed unit does get converted to a forensic unit, how this may impact our Medicaid waiver for the 16 beds, how that may impact or not impact our Medicaid reimbursement for those 16 beds in the state hospital?
Sure.
Because it's physically, the buildings are physically connected. The wings are physically connected.
Yes, so just to kind of paint a picture. So VPCH has essentially 2 residential wings. One wing has 2 8-bed units, and another wing has a 5-bed unit and a 4-bed unit. So those 9 beds, that second wing is the wing that we're contemplating for the forensic facility. Those wings are not connected, but the building itself is connected, right? So they would share common space. There are 2 yards, so they could separate the yards. But the common spaces, the library, the greenhouses, all of that would be shared. I will note that during COVID, when we were really struggling with staffing, we did actually move the residents of MTCR, now River Valley, into VPCH in those 9 beds because we needed it for staffing purposes because we just didn't have enough staff to staff both. And we were able to do that, right? So they each kind of had their own yard. And what we did is we just took turns sharing the rooms so that the populations did not interact. But
interrupt you there because they're both under, they were both mental health. It wasn't forensic, and the waiver is still in place. I mean, the folks who are in Middlesex are not there for forensic purposes. They're there for mental health purposes.
Correct.
So by moving those folks over to the 9-bed, you're still keeping it within the mental health purposes, and you're still within the waiver for Medicaid. So
yes, so that was just an example of how it's possible in terms of space to have different ones. So we are in a phase down right now. So we can't have 25 beds. The federal government has been really clear about that. We're the only state, I think, right now that had been previously allowed to have more than 16. So right now, those 9 beds right now are not our general fund anyway, because we're in the process of winding down. So that's why we don't see a financial impact. We're already using general fund for those beds. CMS has what's called a separate and distinct part. So there is a mechanism where you can kind of have one facility that is kind of 2 different facilities, licenses 2 different things. We have had some kind of initial conversations with CMS about what a separate and distinct part would look like. And if we could do that, we won't really know for sure, right? Until they can come out and look at it once it's up and running. But based on conversations we have, we do feel like it is a viable option. However, part of why the original bill didn't say anything about VPCH and why we asked when they wanted to put that in there that they include the word initially is that it gives us flexibility that if for some reason Medicaid does decide that having it there would jeopardize the ability to use Medicaid funding for the remaining 16 beds, we would have flexibility to move it. So right now we do think it is okay, but we are trying to build in contingencies in case at some point Medicaid changes their mind.
Okay, because that's going to lead me to some questions for BGS. So Wayne, you have a question, then I'm
You
going
may
to
have
shift
answered
it
it,
over.
'cause my question was, legal, legally talking with Medicaid, can they haven't assured you that the way that you're proposing to construct this or separate these 2 entities would qualify as separation under their rules or whatever? You can't get clarity from them and or you have to wait and build it before you find out?
My understanding right now is that that's where those initial conversations went.
And that happened, just gives the committee a little bit more information. When we were looking at replacing Middlesex and building a new secure residential, that was the same conversation that occurred. We were looking at a place in Berlin where the police barracks are now, but we had that as the state library land. And this committee was looking at that property to do our 16-bed secure residential. And we couldn't get clarity, could not get clarity from CMS until after it was built. And we said, do we want to spend this kind of money in close proximity to the current state hospital and not know if we're going to get Medicaid reimbursement for these beds until after we build it? So this is the same response now that we had for the secure residential. That's why we didn't build it there, because we didn't want to invest the money in building it and then find out later that Medicaid didn't cover those beds.
Seems like a congressional problem.
Well, this has been federal since the 60s.
This is, I
So-
would note, a little different than that though, right? Because those were all folks kind of under our care and custody, and they were folks that we were seeking Medicaid funding for. In this case, we are not seeking Medicaid funding for the forensic population. We know that will be general fund. So there is a little bit of a difference between when we were looking at replacing River Valley and this facility.
But still, the decision-making timeframe is about the same. And the question is, you've got a whole building here with 3 wings. And one of the wings is being proposed to be converted. And then it's talking also about shared space. So this is where I'd like to shift to BGS a little bit. I don't want to put the commissioner on the spot, but I'm going to.
Happy to.
I'm a little concerned when you're talking about concerned space, because it's beyond the yard, the rec yard. What about dining? What about day rooms? What about program rooms? Is all of that insular to the current 9-bed wing? And also, if you're going to do EIPs, do you have a seclusion room already there in the 9-bed unit, or they're going to need to be some renovations there? So I'm opening that up. I mean, I don't know if you want to come up to the hot seat, Jennifer, or if you just want to stay there up on the side.
Whatever works best for you, Madam Chair. So for the record, my name is Jennifer Fitch, and I'm the Commissioner of the Department of Buildings and General Services. To be fair to everyone, BGS has not been involved in any of these conversations.
That does not surprise me.
Fortunately, I'm not equipped or able to answer any specific questions today. I do appreciate you inviting me, Madam Chair, to sit in on the conversation. Because that will start a dialogue between myself and the Commissioner of DMH to start talking about how we move that forward. To your point, Madam Chair, every population has its own specific requirements, and it's important that we understand those requirements. To your point, if any renovations needed to be made, we would need to define those, and there would be a cost associated with it as well. There may not be, right? We just don't know what the requirements for that population are at this point. It could be perfectly fine the way that it is today. I just can't answer that question because we haven't had those conversations.
And that's my concern. And it
Well, I can
depends.
say, oh, sorry, Madam Chair.
No, it depends again when the forensic program gets set up and established. But we know if there's any renovations that need to occur in this wing, we've got to get started on that pretty quickly. We can't wait until the program's up and running and then look at renovations, because we have to get started on that. And is there a dining area and a cafeteria or seclusion rooms or program and day rooms already in that 9-wing part of the hospital?
Yeah, so
Is
I can
there-
answer some of that. So there is already a seclusion room on the unit. So overall, we don't anticipate the need to do any real renovations, right? As I said, we've already had this population, a similar population residential level in the hospital, and we didn't need renovations at that time. Generally, a hospital has higher requirements than a residential, right? So we don't expect that there would be any like fire code issues or anything like that in terms of the units themselves. In terms of food, people eat on the unit. So the food is brought to the units, and there are general areas within the units with tables where people eat. There are spaces amongst the units themselves that can be used for office space, meeting with clients, that sort of thing. And then, as I said, we do anticipate the need to schedule the different rooms for uses by the different populations, but we don't think that we need any renovations to do that. Just like we did before, half the day will be units B and C that get to B and D, that C and D, sorry, that get to use the library. And then in the other half of the day, A and B do. So we don't anticipate that there are any big renovations that need to happen. That the structural components of the facility that we need are already on the units, which is partly why we haven't had conversations with BGS, because we don't really anticipate needing them to do much for us.
You might if CMS says you can't share those particular rooms. You don't have an answer to that at this point, and you won't until we really take the steps to convert those 9 beds. But what you just said, there are some rooms there that are used right now with the state hospital folks that you anticipate would also be used by the forensic folks at different times. What does that do to our 16 beds for Medicaid reimbursement? That my naive way of looking at this, because I've been dealing with this since 2005 with IMDs and Medicaid reimbursement for mental health beds, that raises a red flag with me in terms of what CMS may think about our 16 beds in the mental health hospital in our Medicaid. Now, maybe I'm wrong, but this is not new. This is not new to some of us who have been trying to replace the state hospital since 2005 and dealing with the IMD issue and CMS. It really raises concern that some of the rooms are going to be used for both populations, and how CMS is going to weigh in on that. John?
I would also question the level of security. I mean, it's supposed to be secure, and all of a sudden you're moving people into areas that may not have the proper level of security.
I'll just note the whole hospital is secure. So right now our folks are coming off the unit and going to those common areas. So there are all of the facilities locked, right? Both with badges and keys. So you can't get off the secure areas without using both. And so there's administrative areas and entry areas. Those are outside kind of the circle of higher security. We don't have any security concerns about folks they already walk amongst the hallways to get to the common areas.
So the 3 wings are, each wing is a closed unit?
So each wing has 2 units, and they share a nursing bubble. And then they are separated, yeah.
But they're locked units?
All of VPCH is locked. But yes, so the units are locked, the hallways and the common areas are all locked. Everything is locked at VPCH essentially.
So it's locked between the 9-bed unit. That unit is locked. And then the other 2 wings that each have 8 beds, those are locked as well.
Oh yes, meaning like someone couldn't come off the one wing and go to another wing. Yes, absolutely. They cannot actually get out of the wing unless a staff member uses badges. And I'm not sure if it's just badges or keys might just be to get outside the facility, but yeah, you need a badge. And so what they do, they monitor, they don't allow people in the hallway unless there are staff in the hallway to monitor that.
Questions? So that's what this committee is going to be looking at in terms of beds as the program is developed and worked on with House Judiciary Committee, House Healthcare Committee, and House Human Services Committee. So there's 4 committees looking at this piece of legislation at this point. So it's lunchtime, and this is our first walkthrough. Questions? Anything else, Karen or Jennifer, Commissioner, want to weigh in?
Just that If it would be helpful to the committee, we're happy to provide a floor plan so you can see it visually as it stands today.
That might be helpful.
We can follow up with that.
Anything else before we finish up? Thank you, Karen.
Thank you for having me.
Thank you, Jennifer. And we're gonna break for lunch and then